Hello, everybody. My name is Fatima Asmal, and I am the MD at Ruth and Wessels Attorneys, RW Attorneys in Pretoria. With me is my colleague, Mr. Nelson Tiani. Today, we are going to be talking to you about the Employment Equity Act amendments that came into effect on the 1st of January 2025. Nelson, good morning and welcome.
Good morning, Fatima, and thanks for having me.
Nelson, tell us, who does the Act apply to?
All right, the new Employment Equity Amendment Act that came into effect earlier this year, was on the 1st of January 2025. It applies to employers that employs more than 50 employees. In effect, previously, a small business had to comply with the Chapter 3 of the EEA, which included employment equity, planning, and reporting. Now, it's only designated employers, and designated employers has been redefined as employers that employs more than 50 employees, Fatima.
Thank you. And what are some of the key changes that employers can expect from these amendments?
Okay. The Employment Equity Amendment Act, or the EEA amendments, has brought about 5 changes. And then I'll briefly inform you or tell you what these 5 changes are. Firstly, it brought exemption for small businesses. What that means is that because previously small businesses has to comply with Chapter 3 of the EEA, which included employment equity planning and reporting. Now, business employing fewer than 50 people are exempt from submitting the EE reports, and therefore easing the regulatory burden on those SMEs. That's the first change that is brought about by the EEA amendment. The second one is the so-called sector-specific employment equity targets. What this means is that the Minister of Labour and Employment can now set equity targets for different industries, yes, enhancing balanced representation and for designated groups that will include race, gender, and disability across all the occupational levels. The third one is the stricter compliance and monitoring requirements. What does this mean is that designated employers must now actively consult with trade unions and employees representatives, when implementing employment equity plans. The fourth change that was brought about by the EEA amendments is increased compliance and monitoring enhancement, in that now the labor inspectors must enforce stricter compliance regarding the Act. And then now the fifth one will be certificate of compliance, in that businesses now need to engage in government work, that are engaged in government work must obtain a certificate of compliance. Those are basically the 5 changes that were brought about by the EEA amendments that came into effect on the 1st of January 2025.
Thank you. And how can employers prepare for these changes?
Again, reverting back to the 5 changes that I've referred to, Fatima, the employers must look at those 5 and then do one of these 5, do 5 of the 5 things that will commensurate with the things that I've mentioned as key changes and requirements. Firstly, they must assess their business category. Secondly, they must stay informed on sectoral targets. Thirdly, they must ensure consultation processes. Fourthly, they must ensure that accurate record keeping are put in place. And lastly, they should ensure that they plan for compliance inspections.
Thank you. And Nelson, maybe just in conclusion, what is the purpose of these amendments? Because it's important to understand the purpose before you implement. So if you could just tell us.
Yeah, well, there are multiple purposes that is this significant changes has brought in the workforce in the labor market. But more importantly is that the Amendment Act aims to create a more equitable workforce while
Yes.
streamlining regulatory compliance.
Thank you. Well, there you have it, a concise summary by my colleague on the amendments, how to prepare for them, and how to implement them. We hope that this video has been helpful to prepare you to be compliant for the amendments to come. And if you need any assistance in interpreting the amendments, please contact us. Thank you very much for listening.